A very warm welcome again. I would like to welcome you to the second part of our conference. We have to begin with an apology for the slight delay caused by technical glitches. I hope that we are not going to be delayed any further. Now over to Mr. Rafael Gorski, the Director of the European Network Remembrance and Solidarity and co-organizer of this conference. Director, thank you very much. A very warm welcome. I would like to welcome everyone listening in on their computers and laptops and telephones. A very warm welcome to our panelists. I'm going to introduce soon. I'm going to introduce our panelists soon as well. I would like to also point out that we are recording a podcast available for future replay. We are now going to be focusing on law versus lawlessness, legal issues stemming from World War II in contemporary Europe. We are going to be basing on reflections by historians and our invitations have been accepted by Professor Jan Rydel, Professor Stefan Leinstedt, Professor Łukasz Adamski, and Dr. Oldřich Tuma. We have 4 participants in the second panel. We shall be handing over to our first speaker without further ado. Professor Jan Rydel has agreed to deliver a general introduction to the panel. Thank you very much, ladies and gentlemen. I have decided to do something that I hope we will be able to fit in these few minutes. I would like to set out the playing board for what we are going to be talking about. Let me start with the following question. The 2 countries that always come to mind whenever we talk about World War II, that is the Federal Republic of Germany and the Russian Federation, whether these 2 countries are truly the correct parties to any legal dispute concerning World War II, given contemporary Europe realities. Secondly, I would like to point to the similarities and differences in the approach of both countries to their own history and to World War II in particular. I believe that the approach of both countries may be considered a certain forecast, may be seen as a certain forecast or prognosis for any future resolution of legal issues. Let me start with Germany. After World War II, Germany became the arena of a debate, an extensive debate concerning the relations connecting the former German Reich to Federal Republic of Germany. There were a number of factors to be considered, a number of theories to be considered. I will not be mentioning them in detail, but Germany came up with a doctrine which has become the basis for the current German doctrine. In preparing for today's conference, I read one of the opinion of the Minister of Home Affairs of one of the German Länder. He claims that Germany claims that this opinion, that Germany is tantamount to the German Reich, that's rechtsidentisch with the Reich in terms of legality. Sometimes people refer to teilidentisch, partly identical to, because the Federal Republic of Germany spans other territories, and not all of these had been part of the German Reich in 1937. Now, this also proves and leads to a conclusion that the Federal Republic of Germany is a legal successor to the German Reich. Now, in terms of Russia, not long ago, in February this year, Russia became the front of a very interesting and suggestive discussion focusing around the question whether Russia is the legal successor of the USSR. The judge of the Russian Constitutional Tribunal, Konstantin Aranovsky, concluded that the USSR was established illegally or unlawfully, which ultimately means that had been neither a continuity of former Russian statehood, neither can and nor can Russia claim itself or herself to be a continuation of the USSR, because the current Russian Federation was established to replace and in opposition to the USSR. And Aranovsky's thesis, Aranovsky's claim, did not stem from abstract legal ponderings, but rather from his reflections concerning the USSR and Russian Federation in the context of contemporaneity. He said that contemporary Russia should not take upon itself all the blame attributable to the USSR, because these crimes, this blame, these atrocities cannot be borne by the current country. Aranovsky said that anything that can be assumed ought to be done so in the name of truth and mercy. Now, the Kremlin, the Russian government, responded very swiftly. Spokesperson Peskov said that contemporary Russia, de jure and de facto, is a successor of the USSR. This brings me to the other aspect I wanted to discuss. The USSR, neither the USSR nor the Russian Federation had engaged in any complete settlement with the crimes of the previous Soviet system, especially that of the Stalinist era. Neither of these two countries had attempted to resolve the matter, be it in the context of the World War II, be it in the context of the rather lengthy post-war period. There were two windows of opportunity in the country when such an effort could have been made. What I have in mind here is the period of thaw, after political thaw in the wake of Stalin's death, and the final years after Stalin's death and the final years of the communist regime. Now, while during the period of thaw certain efforts had been made to resolve the past, these steps had been taken in view of and to the benefit of victims. An amnesty had been announced. Moreover, certain alleviations were made with regard to the forced assumption of nationality in the context of banishment beyond the territory of the Soviet Union of certain individuals. Nonetheless, I have not noted any cases of attempts to resolve matters for purposes of victims of communist repression and or no attempts had been made to resolve matters with regard to pre-1944 victims. What I'm after here are the Khrushchev, actions taken during the Khrushchev era. Now, in the years 1987, 1993, a number of attempts had been made, also in the final years of the perestroika. The most important one of these had been the 1991 Act on the Rehabilitation of Victims of Political Oppression. The Act also provided for material support, financial assistance. The 1991 Act also provided for prosecution of prosecutors and judges found guilty of Stalinist-era crimes. Nonetheless, regardless of what was put down on paper, no actual action was taken. Financial assistance, while financial assistance had been provided or assigned in certain cases, no actual persecution was, no attempts to prosecute communist criminals were made. Actions were taken to rehabilitate the Communist Party. Moreover, the vetting procedure had not been successful, and neither was any attempt to take over previous communist archives. Now, it goes without saying that there was the Memorial Association was established. It was formed in 1991, and it was very successful. And it remained a permanent, a fixed component of the rehabilitation landscape. Moreover, the Russian party admitted to having committed the Katyn crime. After 1993, there are only a few acts which can be mentioned in terms of trying to set the clock back and eliminate certain issues. Now, with regard to actions taken in Germany, until 1950, any actions to resolve the matter had been attributable to four powers occupying Germany. And 5,000 persons were prosecution, 1,076 of whom were sentenced to death. 18,000 persons were tried in the Soviet area of influence. 117 of whom were sentenced to death. Now, the USSR had other measures to be taken. 12,000 out of the 18,000 were transported to the interior of the Soviet Union. After the German and federal and democratic republics were formed respectively, the USSR handed over those under prosecution to the German judiciary. And the process was actually stopped. The German Federal Republic had not really engaged in such measures, and neither had the German Democratic Republic. For a number of reasons, primarily for reasons tying in with the avidity shown by the Soviets. Furthermore, since everyone was aware of how harsh the Soviet system was, all persons, all former war criminals escaped the German Democratic Republic, seeking refuge in the West. Contemporaneously, the process of denazification, the denazification process was stopped. In 1951, in the Federal Republic of Germany, amnesty was introduced, and very peculiar, very specific acts of law were adopted. These acts of law allowed a mass returns of former Nazis to positions in public service. We are very much aware of shameful incidents, such as, for example, in the situation in the Bundeskriminalamt, an authority which was managed for years thereafter by former Gestapo and SS officers, persons who should have been tried for their wartime crimes rather than offered public service. Most recent analysis of the Auswärtiges Amt of the Ministry of Foreign Affairs proved that at the turn of the 1950s and 1960s, the Amt had actually employed more NSDAP members than under Hitler, obviously former NSDAP members. Now, there was another phenomenon of the time, another signum temporis. A very peculiar post-Nazi clique was established in the German judiciary. Until the late 1970s, that clique had actually done a lot to hinder and prevent and slow down any historical settlement procedures in Germany. Now, since the late 1950s and throughout the 1960s, resistance arose in the Federal Republic of Germany in terms of the lack of action taken. In 1958, a very famous headquarters were established in Ludwigsburg, an institution with a very convoluted name, which I will not quote here. The Ludwigsburg headquarters employed politically involved prosecutors who were tasked with gathering information concerning wartime criminals and drafting indictments, acts of indictment. Now, the archives of that institution comprised 700,000 names. That is the largest collection of names ever known. And in all probability, that was not 100% of all criminals. That was just quite an extensive list of individuals who merited closer scrutiny. Now, Ludwigsburg headquarters had a capacity to take action against 100,000 individuals and drafted 74,000 acts of indictment. Now, Ludwigsburg and the previous trials allow us to conclude that 16,015 war criminals were charged, of whom 6,500 were sentenced, of 182 of whom were sentenced given the highest sentence, that is life. I understand that Professor Leinstedt will be talking about it, but in the 1950s, when the attempts to resolve historical disputes began slowing down, certain other actions were taken as well. Professor, I understand that we will be able to take that motive up after all that gentleman's finished, but just one sentence of a summary, if I may. The legal succession of the Federal Republic of Germany and the Russian Federation goes without saying. I would simply want you to notice the difference in the approach taken by the Russian Federation and the Federal Republic of Germany, respectively. The action taken by the Federal Republic of Germany were flawed and led to a number of scandals. Nonetheless, efforts were indeed made, had indeed been made to settle certain historical disputes, and actually the country has undertaken certain measures. Thank you very much, Professor. It goes without saying that your introduction will give us an assumption for further speakers, both by Professor Leinstedt as well as Dr. Adamski. One of whom will be talking about Germany, the other about Russia. So Professor Leinstedt and Dr. Adamski will be talking about those two respective countries. Professor Leinstedt of the Taghochkolleg in Berlin. The professor will speak English, but understands Polish flawlessly. Professor, what is your take on the matters of historical settlement of the past, including the legal issues? What is your take on the German position currently and in the past? How do you see that position? Do you see any option of developing it?
Invitation and for the interesting questions, and I will address them all but in a row. So first of all, we have to see when we talk about the German compensation that most of this compensation was due to claims that were pushed against Germany. And then again, we have several categories. There is, first of all, there is the restitution. So giving back what was looted, for instance. And it's easy to restitute a picture. Once you have it, you can give it back. You can restitute social benefits like pensions for those who were stripped of their pensions. You can give it back, and it's relatively easy to give exact numbers when we're talking about restitution. There are issues with it, but it's much easier than when we talk about compensation and amendments, which is the second pillar of German reparations. Because when we talk about compensation, this is mostly moral issues. So the question here is, what do we pay for someone who was incarcerated in a concentration camp? What worth can we say has one day in a concentration camp? The Germans, and under international pressure, came up with a figure, and it's actually 5 marks. So it's 2.5 euros, which in the 1950s was a lot more money, but still that is what you get for one day in a concentration camp. And these issues for compensation, you of course have when there are health issues, like for instance, how much to pay for a lost leg, or for someone who is suffering from trauma, which is actually something that is not yet addressed even in 2020. Then there is a third pillar, which is the so-called, so to speak, legal restitution. That means we have to address all these injustices that were done, like, for instance, Nazi law. And of course, this had also to be undone. And under this pillar, one can summarize what Professor Riedel just addressed. This is the persecution of perpetrators, because if you want to speak about compensation, then of course moral compensation also means that all the guilt that has come upon the German state has also come upon many individuals, and to persecute them and to put them in prison is something that is very important. Then we have issues like moral obligations. That is, obviously one has to ask for forgiveness, one has to ask for pardon, one has to do cultural project, and one has obviously to commemorate, like we do in many of our German memorial sites for concentration camps. And then there is, of course, the individual compensation for German victims. Here, listen to what I'm saying, not victims that were victims due to German crimes, but victims who were Germans. There are, of course, those Germans who were persecuted, but also Germans paid a lot of money to those who were war refugees, who suffered from forced displacements. So after 1945. And here we can say, if we try to sum this up, then we'll find that, first of all, most of the compensation only happened due to international pressure. Rarely anything happened because the Germans were doing it out of their own ideas, because they felt that it's necessary. They only did it when they were pushed for it, with the sole exception, of course, of the German victims, because they, as German voters, had influence in German politics, in German interior politics. They were important voter groups, so they received money. And when I talk about voter groups, you will notice that I'm speaking about West Germany. We have two German states after 1945, so this gets a lot more complicated when we also talk about the GDR. But maybe we can shift this to the discussion. So in general, the closer as an individual, the closer to the German nation you are, the more money you get. So German Social Democrats, who were working for the German state, and in 1933 were persecuted, put to a concentration camp, they really got a lot of restitution, and they got compensation that you can consider adequate. Many others did get very few or almost no compensation at all, especially when we talk about victims living in Eastern Europe. If we try to sum this up, how much was paid in compensation and reparation? I'm not talking about the Germans from forced displacement. So for German crimes until 1945, the overall sum was some 75 billion euro. All the German compensation measurements, and actually this sum is complicated because, as you are well aware, in 1950, money had a higher worth than in 1980 or in 2010. So but you have to be a little bit careful when you talk about this sum. But again, 75 billion euros that it is. And when we look at states who received it, then we can see that between 1959 and 1964, all the states of Western Europe received money. They received roughly 1 billion euros. But obviously the states in Eastern Europe received nothing because they were to be compensated by the GDR, the East German state, and all the compensations through the GDR were something that had to be negotiated with the Soviet Union. So at the time being, in the 1950s, it was actually the Soviet Union who decided how much money or goods, foodstuff, coal, whatever, for instance, Poland received out of the compensations that the Soviet Union was receiving from the GDR. So they just handed on compensations. And actually this led to the fact that Poland, Czechoslovakia, and so on, they received almost nothing that is actually notable. So then, this is why we have open claims. We have open claims by individuals who received very little money. So, for instance, I can tell you that the average Polish citizen who had suffered under Nazi crimes by the year of had received by the year of 1995 some 405 marks, which is 200 euros in nowadays worth. And actually it has not become so much more by the year 2020, despite the fact there were compensations, for instance, by the program for forced laborers, and here people received some money, but it's not really substantial. And then we have claims by states. There is at the moment a claim by the Greek state. There is the same in Poland is currently also preparing something. We have not yet actually. We hear a lot, but there's no official document where they say, well, this is what the Republic of Poland demands of the German Federal Republic. We still have no official document. And we have the problem here that, of course, is the general problem with all compensation is how to calculate the costs. As I said, restitution, giving back painting is relatively easy. Calculating the cost for something that was destroyed, for someone who was killed, is really a difficult issue. And if you look at the example of the Zamek Królewski in Warsaw, it gets even more complicated. So if you want to compensate Poland for the destroyed Zamek Królewski in Warsaw, you have the question, well, are we talking about 1939's worth? Are we talking about what the reconstruction costed? So with elevators inside and so on. And if we're talking about that, who will get the money? As you know, the Zamek Królewski was rebuilt in the 1980s, and it was rebuilt due to an effort mostly by Polish and Warsaw citizens. So it was not the state who gave the most money, but it was those citizens. So if Germany is to pay compensation, who will receive the money for the destroyed Zamek Królewski? The Polish state? Those citizens who paid for the rebuilding of the castle. So all this is completely is really problematic, and I doubt that it is possible to calculate an exact amount of money. You can try, of course, and actually any calculation will show you the immense destructions that the Germans caused in Eastern Europe, and which the Germans nowadays are totally unaware of. And so for this alone, it's worth taking the effort. But the thing is, if you come up with this huge sum, you have to deal with it, and you have to see what we can do, what the Germans will do with it. So if Poland, for instance, asks for 1 trillion euros, then obviously no German chancellor will pay this, because they say, well, we have to declare bankruptcy. However, at the same time, the Germans always declare themselves responsible and say, well, this was our war, and we have a responsibility. So how to solve this issue? And I think what we're talking here, and this is all compensation politics, is always a symbolic policy. But a symbol is only then a good symbol if it is accepted, and B, it's a symbol that actually means something to those who pay for it. So if Germany then says, well, we'll give you 5 billion, then it's actually nothing. A symbol is then a good symbol if it really, if it can be appreciated by the others. And this means that a symbol, usually, if we're talking about compensation, it is something that has to hurt the Germans. I mean, literally, it has to hurt them. It has to be a substantial amount of money, because if it's not a good symbol.
Panie profesorze?
Yes.
Professor, and we'll get back to this topic. And I will be asking questions of yourself and Professor Riddle after this session, questions regarding the disparity, the rift, the split we see in German policy. On the one hand, what you talked about, so this these declarations, and not only declarations, but a visible sense of responsibility for World War II and for the Holocaust, for the death and suffering of untold millions, and this lack of will to compensate for any financial compensation, especially regarding the nations of Central and Eastern Europe. And we will be getting back to this in a moment, shortly, but if you'll allow me, I'll now hand it over to Dr. Łukasz Adamski, who will tell us about the sense of responsibility and the lack thereof on the part of Russia, or the part of the Soviet Union, because I'm sure he'll be talking about in a broader time perspective. Dr. Adamski, Director. Because Łukasz Adamski is the Deputy Director of the Center for Polish-Russian Dialogue, so please go ahead.
Dzień dobry, Państwu.
Good afternoon, ladies and gentlemen. Most usually we are not aware to what extent the Polish-Russian relations are actually burdened with a separate legal position that Russia would usually assume with regard to certain matters from the period of 1939-1945. The influence is dual in nature. Obviously, there are different positions taken with regard to the return of cultural assets, but you also have to understand that there are different positions taken with regard to the historical remembrance of Russia and related developments associated with the production of maps, for example, or interpreting myths and different historical developments. Whenever Russia refers to or references such matters on the international arena, it causes certain tension. It also has to be pointed out that Russia may definitely use its own paradigm in terms of trying to respond to the question to what extent it is a continuator of previous traditions or history. Nonetheless, today's Russia is definitely tantamount to USSR. In 1991, we were witnesses to secession rather than collapse of individual republics. If the situation would have been quite different were Russia, for example, to apply for UN membership as a completely different state, but that did not happen. Now, we ought to refer to a number of issues concerning World War II history. First and foremost, let us refer to the Russian aggression of September 1939, September the 17th to be precise. We believe that this was an aggression, and a similar position is taken by a number of Western countries, but they believe it had been a humanitarian intervention. On September the 17th, there was no such thing as Polish state any longer. That was no man's land, a certain legal void. And this void had been, quote-unquote, filled by the Soviet power, and allegedly their intention had been to save the local Ukrainian and Belarusian residents. Nonetheless, the narrative in the current Russia has not changed. They claim that there was no such thing as aggression in September 1939. No aggression, consequently no occupation. Poland had lost its handle on its territory in September 1939 as a result of the downfall of Polish statehood. Now, obviously, we ought to consider what the meaning was of incorporating such cities as Vilnius and Lviv and Przemysl to the Soviet Union. As we all know, Poland did not recognize that decision. Nonetheless, the Soviet Union began treating the local residents as their own. The Polish government had repeatedly filed a protest after protest, objection after objection. Nonetheless, the USSR did not budge from its position. Obviously, we ought to also ask the question whether there was a state of war between Poland and Russia and USSR in the years 1939-1941. It is quite incredible. Even some Polish sources claim that there had been no such thing as the Polish-Soviet War. Some people claim that a war had not been waged officially. But no international documents require a war to be formally waged. But I would like to remind you that Prime Minister Władysław Sikorski, in his address of March 1940, had mentioned the Polish-Soviet War, and such position had been upheld by the Polish diplomatic corps. Obviously, we ought to also answer the question, when were the actual borders set out in the years 1939, 1940, 1944? For example, was Białystok handed over to Poland or Belarus or Russia in 1940 or 1944, or did simply Poland reclaim her sovereignty? There is another matter that is of huge importance in that context, namely, whose was Gdańsk, and who did Gdańsk belong to during World War II? The Nuremberg trial had concluded that no territories annexed throughout the war can be recognized as territories belonging to the annexor, which obviously means that Gdańsk had been under occupation. But in a Russian case, for example, Russian authorities would claim that certain locations had been full of German images, for example, or paintings or statues. So why is Poland referencing any, or why is Poland filing any kind of claims? Now, obviously, we ought to also consider the borders of 1939. For example, in the context of Juliusz Słowacki's manuscript, very valuable manuscript, the travels to the Holy Land, which was on loan to the Museum of Königsberg, and then it was only recovered after it was recovered by Soviet scientists, and Russia is reluctant to hand that manuscript over. Well, Doctor, probably we would go on. We could talk about subsequent examples and subsequent artifacts. Probably Königsberg is not the only example. Since we are under time pressure, I will now hand over to Dr. Oldřich Tuma from Prague to speak about responsibility and accountability and blame and reparations for World War II can be approached and had been approached by Czechoslovakia and the Czech Republic. It is quite interesting because in 1945 we had a single Czechoslovak state wherein the attitude towards the Nazi Germany and the Third Reich had been different between the Czech and Slovak republics. Doctor.
It's nice to see you all. I regret we are not in Warsaw, but this is also remarkable, and thanks to the organizers for doing all technical work. So I will speak about some legal issues of the time of the Second World War, which had impact or even still has impact on the relations between, as you said, Czechoslovakia and then Western Germany, or Czech Republic and Unified Germany. Today, it will be more specific topic than much wider topics of my predecessors, and I try to be really very brief. So I will speak especially about legal consequences of Munich Treaty as a topic of discussion between Czechoslovakia, Czech Republic, and Germany, and then about presidential decrees of Czechoslovak legal norms, which which dealt with Germans 1945. What's for me interesting is to see that those two complexes of legal norms were used by both sides in almost mirror-like way for political use in different times. So the first case, Munich Treaty, was especially important during the talks between Czechoslovakia and Western Germany about mutual recognition, 1970 to 1974, and those Czechoslovak-German negotiations are really very difficult, extremely difficult. As you know, they lasted much longer than Soviet-German or Polish-German negotiations. They lasted for almost 4 years. And the issues of the past, and especially the Munich Treaty, was really a burden, and it dominated the talks in this time. Yeah, and both sides, from the very beginning, devoted a great attention to this issue. So they were materials, very extensive materials prepared by Czechoslovak Ministry of Foreign Affairs for Politburo of Communist Party for those negotiations, and the most space was devoted to the Munich Treaty. And on the other hand, there were also documents prepared by Ministry of Foreign Affairs in Bonn, 1970, and then again 1972. I will briefly quote from them, so to show that the opposition, the opinions are quite different, and according to the Czechoslovak Ministry of Foreign Affairs, in possible negotiations, the Munich Treaty will be treated from our perspective as non-existent. That is nullity from the very beginning. On this principle, we will insist. There is no backing down from it. No West German government can expect from any Czechoslovak government that a settlement of mutual relations will be achieved so long as Munich is not completely rectified. And the German position was the Munich Accord was created under the law of that era. The position taken by the Czechoslovak side that the Munich Agreement is to be considered null from the very beginning will not bear critical analysis from the standpoint of international law. And
Jakie
in
to
fact,
jest?
NATO
Bo
side
zaczęliśmy później, więc
was ready to step.
czy na ile, że tak powiem, możemy jeszcze rozmawiać, a na ile
Rafale, słychać
gdzie musimy...
się?
So can you hear me? Again, the problem?
No.
You can't
Continue, please.
Sorry? May I go on?
I'm sorry for interrupting you. Please speak.
Yeah, okay. So, and so the heart of the problem was the chronology, so to say. Was the Munich Treaty invalid from the beginning, as the lawyers would say, ex tunc, or from now, ex nunc? Even the German journalist of the time started to call the two main persons, Paul Frank on German side, and here she gets on the Czechoslovak side, Herr von Tunc and Herr von Nunc. Yeah, so there was a very complicated preliminary talks, and the official negotiations started only in 1973, which is even more remarkable that in fact, there was no real meaning of the validity or non-validity of Munich Treaty in early 70s. The Federal Republic did not question the territorial integrity of Czechoslovakia within its pre-Munich border. That was different case than until 1970. No Bonn government explicitly acknowledged the Polish-German border along the Odra and Nysa rivers. So there was no matter of territorial claims nor of money. In fact, before the beginning of those negotiations, Czechoslovak side was thinking about financial compensations and hope that the invalidity of Munich Treaty will be included into the Soviet-German treaty, which was not the case. And when it was clear that there were no compensations negotiated in the Polish-German treaty, so also Czechoslovakia couldn't claim anything. And on the other hand, from German point of view, the German government felt afraid that if the Munich Treaty was recognized as null from the very beginning, that could mean that some former Czechoslovak citizens of German ethnicity would be even then, in the 70s, persecuted for some crimes against the Czechoslovak legal norms, like serving in German army. But in fact, it was not the case, and Czechoslovakia from the very beginning insisted that all, with the exception of war crimes, or crimes perhaps committed by ethnic Germans, anyway, were not expired after 1965. Yeah.
Bardzo dziękuję.
Thank you very much.
I would like to quote a very nice sentence of Willy Brandt. When he signed in Prague the treaty about the diplomatic relations between Czechoslovakia and Western Germany, he said, "Don't make it unnecessarily hard on yourselves and on us. Don't link future cooperation to questions of the past." And in fact, it's still the case. And it was the case also at the beginning of the 90s about the presidential decrees, when then the German side insisted that Czechoslovakia must repeal it retroactively, and so on, so on. Thank you for attention.
Bardzo dziękuję.
Thank you.
Czas nas...
Thank you very much. Well, dear gentlemen, since our time is slowly but surely coming to an end, I would like to ask a question, identical one for all our speakers. Yesterday, the a declaration was made by the ministers of foreign affairs of Bulgaria, Poland, Czech Republic, Hungary, and the US. And this declaration states that there should be a joint position of solidarity with regard to past war crimes. It is a beautiful and rather lofty idea. Nonetheless, I would like to emphasize that you have managed to draw quite an interesting landscape also in the context of the 75th anniversary of the E-Day. Nonetheless, do you believe that 75 years after the war has the moment come to talk about the peace treaty? Is there any kind of chance? Do we have an opportunity of such pact being discussed and evaluated and possibly signed and provide families of victims with appropriate compensation? Professor Rydel, Leinstedt, Dr. Adamski, Dr. Tuma in turn. That is a very complex issue. It goes without saying. In all probability, the initiative, any such initiative, could trigger numerous doubts when it comes to the Federal Republic of Germany, for example, because the 2+4 unification treaty contains a clause to the effect of it closing and any consequences of World War II. The issue referenced by our moderator in all probability escapes any true assessment by historians. I think that even lawyers could have a huge problem with drafting a uniform Polish and German position with regard to the matter. It is a political matter. Thank you, Professor. Professor Leinstedt.
Political question, and especially because as Professor Riddle just said, the political implications are so huge. A peace treaty for Germany would mean that they again have to deal with the compensation for states, and that means for the compensation for all those states that Germany was at war with. That's all the states, basically, of the world, or at least in Europe. And because until now, they said, well, we'll have the final regulation of all those compensations. We'll deal with that after a peace treaty is formally signed. So the German legal position is, or was for a long time, well, there's no need talking about that because we have no peace treaty. And this is, of course, very convenient for Germany. So the thing is, we have so huge political implications that I think the symbolic gesture, the important symbolic gesture, which I would really appreciate, is completely dominated by this legal issue, and I think that's why we won't see signing of a peace treaty in the near future.
Bardzo dziękuję, panie profesorze.
Thank you very much, Professor. Dr. Łukasz Adamski. Well, both yes and no. Now, both yes and no. With regard to Polish-German relations, I think the issue has been closed. The Potsdam Treaty has been, or the Potsdam Accord had been signed, and then actually the 2+4 Accord of 1990 closed the matter, closed the case. Now, how do we regulate the entire issue with Russia? Also when it comes to the Pribaltica states, also when it comes to the years 1939-1950. Now, I believe that should a future democratic Russia wants to enjoy good relations with its immediate neighbors, Poland to Ukraine, she will have to uniformly condemn all the atrocities of World War II. And Russia is definitely aware that this would be followed by reparations, and Russia would have to make her own decisions. Now, the overall arrangement can definitely be considered. Now, in closing, I believe that until such moment, we in Poland ought to also organize and arrange and confirm our own position. So we should begin with our own legal order, starting with 1944. Thank you very much. I believe that with regard to our relations with Germany, I don't think that these matters have been closed. And I believe also that, especially with regard to politics, a lot remains to be done in terms of finances as well. And Dr. Oldrich Tuma.
Very briefly, as the other colleagues say, I think it would be more political symbol, important one, but definitely we can't expect any compensations or reparations. In Czech-German case, there was Czech-German Declaration of 1997, which tried to deal with the issues of the past and proclaimed them closed, and both sides apologized, and so on and so on. So, but you can repeat it again and again. What's for me really interesting is that the actual Czech public discourse about Second World War focuses more on Russia than on or Red Army than on Germany, and this is a bit fascinating how the history or memory of history could change within decades. We'll see what the future will be.
Szanowni
ladies and gentlemen, dear speakers, we have obviously touched upon assorted matters potentially leading to compensations or reparations relating to World War II. Obviously, none of these matters have been closed. It is absolutely impossible over 1 hour or 1.5 hours. Ladies and gentlemen, we would like to encourage you to send in your questions. All our cooperating institutions have their websites and Facebook fan pages. We will try to do whatever we can to convey your questions to our speakers and respond to them. Nonetheless, the time has come for us to close the meeting. I would like to thank Professor Riedel, Professor Leinstedt, Dr. Adamski, and Dr. Tuma. Thank you very much, and please join us at 1:05 for the third and final panel of our conference.